Good morning, everybody, and thank you for coming back. I hope you're all well refreshed after your coffees. The more eagle-eyed of you will notice that Jane Malcolm was down to actually chair this session, and I am not Jane Malcolm. My name's Ben Fisher. I'm Head of External Communications here at the SRA. We've had to do a bit of rejigging on the chairing due to illness. But if you are a huge Jane Malcolm fan, rest assured she is chairing one of the Better Information sessions, so you can see her there. Now, before we get started on the session, I want to draw attention to what's on the screen. There's a voting option for this session, and that is voting through our SRA app. And you'll see up there 5 topics, and they are starting up a firm, common client account issues, managing succession, when and what to report to the SRA, and offering financial services. Now, this session's, as you'll see from the title, it's about your common compliance issues and your queries. And we've chosen 5 topics which we hear about a lot, we get a lot of questions about, and are very common themes that people have questions for us. So you get the chance to vote through the app as to what you would like to cover, and then in the format of the session, we're going to go and try and get through as many of those topics as possible. We'll probably get through two or three of them, if not more, and you'll have the opportunity to ask questions. So please vote now. You've probably got about another minute to vote, and then we'll see what the results say. So while you busy vote, I will introduce the panel we've got here. So they're all SRA staff, and at the far end we have Jane Allan, who's our ethics manager. She's got well over 2 decades experience providing expert advice on ethics, and I think prior to that was a solicitor working in a high street firm. Then we've got Juliet Oliver, who is our general counsel and executive director of case direction. She was previously a partner at Field Fisher, and she's also worked on high-profile cases at the General Medical Council. After that, we then have Sean Hankin, who's our head of forensic investigation intelligence. He also has more than 2 decades of experience on the regulatory side of things. He's a chartered accountant and previously worked in some of the big accountancy firms. We then have Jatinder Loyal. He's our financial services specialist, been at the SRA for over 15 years, and previous to that, worked as a lawyer in a law firm. And then last but not least, we've got Rachel Lewis, who's our Director of Authorisation and Contact Centre. And in her time here, she's overseen changes in authorisation, which have seen our average times for authorisation go down from 9 months to just 6 weeks. And she also oversaw recently us winning the award for the Best UK Contact Centre. So that's the panel. Now, I'm hoping, fingers crossed, there's already been 1 vote nationally in Parliament today that's got aborted, so let's hope this one hasn't. So hopefully, yes, there we go, we've pulled through the votes. And almost to spite you, I think I'll go for offering financial services as the whole session, because only 4% of you wanted to cover that. But actually, we've got the clear themes there, and the clear favourite at the moment is common client account issues, and then followed by managing succession and reporting misconduct. So what we're going to do is, one of my colleagues here is going to give a quick 3 to 5 minute introduction on the theme, and then we're going to go out to the floor and get questions. Just to note, you can't ask questions through the app, so if you want to ask a question, raise your hand, and there's various roving mics around the room who will try and find you. So, common client account issues. Sean is our man for this. So Sean, do you want to say a few words to introduce that topic?
Yes, thanks, Ben. Good morning, everyone. So our forensic investigation teams travel across England and Wales, visiting firms, and in each occasion they check compliance with the accounts rules. We also have responsibility for reviewing all the qualified accountants' reports, sorry, getting a bit of feedback, that come into the SRA. So from that work, we pick up themes and trends about client account issues and compliance. The 3 most common things we see are around residual balances, around client account reconciliations, and around the use of client account as a banking facility, which is currently Rule 14.5. Interestingly, all of these breaches, if the breaches now, will be breaches under the new SRA accounts rules, which come into effect sometime next year. So I'll take each in turn. Residual balances, the main three things to get across in this is about prevention, identifying those matters, and then dealing with them appropriately. In terms of prevention, good housekeeping procedures help in that regard. So a good habit to get into is to make sure all client account balances are zeroed, office account balances are zeroed before any archiving is done on a file. In that way, you make sure that the information is fresh. There are often small balances which appear on ledgers which you can deal with more effectively just as the matter closes. Similarly, if you're looking at taking over another firm, one of the areas of due diligence that you should focus on would be around residual balances because they can be very difficult and time-consuming to deal with. Saying that, though, all firms tend to have, or a lot of firms tend to have, old residual balances. The main thing to do is identify that you have them, be able to quantify what they are and how long they've been there. Make sure you are keeping the clients informed if you can locate those clients, and then have a clear plan as to how you can deal with those matters. And then obviously to monitor your progress against that plan. There's clear guidance within the accounts rules, and there's going to be new guidance on the new accounts rules. Distinction between how you deal with balances over or under £500. So all those details are there, and the SRA can grant waivers as well as to how to deal with those balances. The next area is around client account reconciliations. Again, it's a key control. It's one of the prescriptive areas that we have in the new accounts rules. What we see on the ground is that we're not having proper three-way reconciliations, so quite often the cash book element is missed off. We see adjustments on the reconciliations going forward for months, more than 1 month, which again shows that they're not being dealt with properly. And what we really need to see is people signing those reconciliations off who fully understand the SRA accounts rules and what those adjustments mean, and making sure that any differences are rectified on a timely basis. And the final area, before I leave you open to questions, is around use of client account as a banking facility. Again, in the new rules, this is we're quite prescriptive about not using client account in this way. I think sometimes firms want to please the clients, so they want to follow the instructions, but this can lead you to using client account as a banking facility. We've got some, what I think is good guidance out now about this area, and it gives some real-life practical examples of what we would or would not perceive as being using client account as a banking facility. The main thing to bear in mind is that there needs to be an underlying legal transaction for any money that you move in or out of client account. And the dangers are quite clear in this area. It could be indicative of money laundering, or it could be present when you find a dubious investment scheme as well, which is another area we have concerns about at the moment.
Thank you very much, Sean. I'd like to look out into the audience and see if we have any hands for initial questions around the account rules or anything that Sean's raised. Put your hand up and we'll get one of the speakers to find you, or one of the people with the mic, sorry. Yes, we've got one there in the middle. If just number 4 could just come in, and this lady there, thank you.
Hi, Jo Creamer from Pinsent Masons. I think the last Cobb and Coffer conference talked about the accounts rules and particularly the definition of client money. Has that been changed at all, or particularly the disbursements question around, is that still going to be classed as client money, or is that still, as was said in the last Cobb and Coffer conference, going to be classed as office monies?
No, things have changed. So when we consulted on the new accounts rules, we took into account people's views, and I think this was one area where people were had quite strong views about the definition of client money. So in the new rules, the money paid on account of costs and disbursements will still be classified as client money, but there is now an opt-out. So firms who just purely deal with client money on account of costs or disbursements, that's the only client money they have. They would no longer need to comply with the full set of accounts rules. And that money won't be classified as client money, and it might mean that more firms can, for example, be removed from the requirement to have an accountant's report at the year end.
Do we have a follow-up question? We've got a woman down the front and a man at the back, so if we could get 2 mics to them, and if we start off with the lady at the front and then go to the gentleman at the back, thank you.
Hiya, Sean. My name's Sarah Charlton. I'm from the ILFM. I just wanted to follow up on that question. If people are opting out, will you have a register in the same way you do for a waiver? Because money on account of costs, some firms will only hold a couple of thousand and some might be tens or hundreds of thousands.
No, we won't have a register. It'll be up to individual firms to make that calculation. In the same way we've got now the exemption for firms who only hold small levels of client money, they no longer need to have an accountant's report at the year end. So it's the emphasis is on the firm themselves to make that calculation and keep in accordance with the rules.
But can I just chip in though? But presumably we will be capturing that information, because as now in the returns we get information about those who do hold client accounts and the money that comes through the client accounts. So you won't need to sort of pre-register with us the fact that you're having the opt-out, but we will be capturing the information about which firms have client accounts and the money that passes through it. So if you're opting out and not having a client account, then we will know that.
Thank you, Juliet. We had a gentleman at the back who had his hand up. Was it by number 4?
Yeah, Ben Johnson from Geldard's compliance officer. One area that I've been quite confused about in relation to using client account as banking facilities is the way in which we're permitted to use our account for things like escrow arrangements on corporate transactions. Historically, it's quite often that the parties to the transaction need to agree some sort of security arrangement for a period of time to support a contractual obligation of some sort. And an escrow account, either a joint account with another law firm or sums held in one solicitor's account under joint undertaking, was a method to achieve that outcome for the respective clients. But the recent guidance suggests that things like rent deposits, which are very similar in many respects, are no longer seen as appropriate use of the client account. And I'm slightly confused about where the line is drawn between a legitimate escrow arrangement securing the performance of parties to an underlying transaction and where you cross over into something like a rent deposit, which may well be for the convenience of the client.
I think between Sean, Juliet, and myself, we could probably answer that together. So I'll start. What we've said on rent deposits especially is that firstly for residential rent deposits, there are government schemes that have been opened up to deal with those rent deposits. They were particularly put in place to make sure that landlords and tenants were protected and that there wasn't a need for people like letting agents or solicitors to use their own client accounts for that deposit to be held there. It's fine. We've always said that where the law firm is providing a regulated service or are providing legal services around the sort, should we say, the T's and C's of the actual rental agreement between the client, between the landlord and the tenant, that there might be a need to hold money there. But once the legal services have ended, there is no need for that money to be held. There is no instruction from either the landlord or the tenant. Sometimes we get questions asked through our professional ethics helpline, which is that, okay, there might be a dispute. Again, it's that word, the might, where you're not guaranteed to be providing any services or you are actually providing any services, there's no need for you to hold onto the client, onto the deposit. For commercial deposits, we're saying the same thing, even though there aren't the government-backed schemes for commercial rent deposits. But again, there might be a need for you to hold on to the deposit whilst you're working through the terms and conditions. But once those services have ended, there is no guarantee that the client will come back to you to re-instruct you on whether it's dilapidations or any other, should we say, dispute, whether it's the landlord or the tenant. So we don't see why firms should be holding on to that money.
Anyone else want to chip in on that one?
I think that probably sets out the position really, which is it's about trying to understand what you're doing while you're holding the money, and if it does link back to an actual with the work that you're doing or sort of the underlying sort of legal job and what you're working through as you're holding through that money. So I think Jatinder sort of explained it, which is that there's no in principle difference. It's just about understanding the circumstances of the actual T's and C's.
Okay, thank you. Any further questions? We've got, I think it's a gentleman over there, and then we've got a couple down the front as well. So if we start off with the gentleman at the back. Number 4.
Hi there. I hope not too practical a question. We see some example, Emesis Saba from Brian Cave, Leighton Paisner. We see some examples where we are sent funds, possibly inadvertently. We have no details apart from a name and bank account number. No one's claims it, and obviously I'm under pressure from the accounts department to make sure that this is put on a client account. We can't link it to a client account. It doesn't get claimed, and eventually accounts want to send it back. And I was wondering what the views of the panel are on the checks that they would expect to be undertaken before funds are sent back.
I'm happy to. So yeah, it's a difficult one, isn't it? So you end up probably putting it on a suspense account while you make your further inquiries. I think the advice probably in the past would have been to send it straight back, and you've done your job. But we're all, I think, a bit more savvy and alert to the risks of money laundering now. So there is further due diligence work that needs to be done for you to satisfy yourselves, and it's probably getting what information you can from your bank in terms of who that money's been sent by. If they're not a client of yours, you won't have that detail necessarily as to who they are, the source of funds, source of wealth checks. So it does put you in a difficult position, but you need to document fully what you've done and how you try to satisfy yourself before you send that money on. Sure. Whether that's back to an account that the bank has specified or back to who it came from.
Yeah, because you'll appreciate that, and thank you for that. It's really helpful that often if it's from the bank and it's not something you recognise, the amount of information they're going to give you is next to nothing bar this is the reference they gave and this is the account number. But the documenting approach makes sense. Thanks.
Okay, there was a couple of people with their hands up down here. I'm going to have 3 more questions on this, and then we're going to move on to the next topic just to make sure we get a variety of topics in. So we had... sorry, there's a gentleman, because if we have one here, just this gentleman here with the beard who had his, and then we'll go to the man at the back who had his hand up, yeah?
Thank you. Roderick McCulloch, Reynolds Parry Jones. I'd just like to ask a question about trusts, whether the new rules will be maintaining the definition of controlled trusts and joint trusts. Just be interested to hear the comments of the panel. Thank you.
Thank you.
The new rules don't stipulate, as the current rules do, the sort of different roles that solicitors can play. So we won't be setting out how the rules apply to whether it's a solicitor appointed as trustee or liquidator or any other role, whether it's, for example, the deputyship through a court of protection. Because what we're saying is that it's client money, and that the job of the law firm in these circumstances is to make sure that client money is protected. There are going to be circumstances where you have been appointed, as should we say, a trustee through courts, and you'll have to make sure that you comply with your obligations to the court as well, and any specific requirements they put on you as that role holder. But in terms of how the client money is managed, there shouldn't be any difference in terms of whether it's through a control trust or through just a normal client account. So there is no specific splitting out in the new rules.
Thank you. And it was the man with the microphone there. If you want to go ahead, yeah.
Thank you. My question is basically a follow-up of the one before. Is identified amount received from the Home Office, especially in immigration cases, say in terms of, say, refund of application monies of the client. The Home Office very rarely provide any source of information who his client is there, and just send the money with the letter addressing to the firm without mentioning any client's name. And when referred back to them, whose client are them, they take so long. In some some cases over 6 months, and in some cases never, and they never come back. So what should be the better treatment of these kinds of entries in the client account, or what should firm do about this? Thank you.
It's difficult, isn't it? Because we don't like the use of suspense accounts, but unfortunately, sometimes there's no alternative. If you have no details of who that client is that the money's coming from, then you need to make an entry in your books of accounts so that they all balance and you've not got adjusting items everywhere in your reconciliations. So I'd say the best thing to do is to use the suspense account, but keep a very close control on what goes in and out of that suspense account, and to try and get better information from the people who pay you that money over. So I know it's difficult to go back to the Home Office and get them to change their processes and procedures, but just to try and get as much information as possible from them, and explain your difficulties that you've got, and ask them why they're not identifying that money. There may be other ways, so the clients that you're acting for may be able to help, but I also understand that with immigration money, it's quite often a fixed fee, isn't it? You know, that you get through each time, so it's not always difficult to differentiate.
Thank you. We're going to have one more question on the accounts rules before we move on to the next topic. So if we have the gentleman at the back end, is he in a waistcoat? Sorry, I'm slightly blinded by the light. You appear godlike almost to me. Yeah.
Hi. We had a client in a personal injury matter. We received the instruction and made a claim on the portal. The other party accepted the liability, transferred us the compensation. But since we received the compensation, we are unable to locate the client. We sent various letters, tried to contact by emails and phones, but we have not been able to contact him. What should we do with the money we received? And also, what should we do with regards to our charges for the claim? Thank you.
I think, as we've said before, that where you receive monies and you can't locate the client, well, our first, should we say, point of advice would be to try and do whatever you can to locate the client. There's numerous searches that can be carried out. One of the benefits of the PI claims portal is now that you have to upload the client's details. It's not just their name and date of birth. You have to upload with as much information that you can about who they are. It avoids the fraud around personal injury as well, in the sense that you know who that client is, and you have to provide some sort of verification that that client is the person that they're saying they are. So in that sense, we're saying that there are systems out there are processes where you can try and locate your client. We live in a world where there's social media, that it's more prevalent than anywhere else, that that you can do checks using social media. A lot of law firms have got social media pages where they can put call outs to say that we acted for Jatinder Loyal, can you please get in touch? So there are mechanisms, but again, if you get to the point where you can't trace your client, then do get in touch with our professional ethics team, and they'll work through the process, i.e. what you need to do in order to send that money on to, whether it's a charity of your own choice if it's under 500, or they're making an application to our ethics team if it's over 500.
And we'll deal with those applications as quickly as possible. You just need to remember to give us as much information as you can from the outset. And if you look at our guidance and complete our standard form, then that means that we will be able to get your application dealt with more quickly than otherwise.
Thank you. I'm going to, it's brilliant we had so many questions. Sean, Jatinder, the rest of the guys all around today after this session are on the stands if you didn't get the chance to ask your question. But I think the second most popular topic we had on the vote was managing succession, which I know is one of the most common queries we get, and also can be one of the most fraught and sometimes traumatic queries we get through to our ethics team. So I'm going to invite Jane to say a few minutes about sort of some issues you need to consider in terms of managing succession, and then again we'll go into some questions. So over to you, Jane.
Life in a legal practice is a bit like a journey. We know where we started, but we're never quite sure where and more to the point when we're going to finish. Today I want you to take away 3 important messages. 1, it's vital to plan for the future. 2, you must save for that rainy day. And 3, it's good to talk, even if it's to your regulator. Planning for the unexpected or managing risk is something that the SRA would say is a fundamental requirement of legal practice. Indicative behaviour 7.3 in the code requires that you identify and monitor business continuity risks. Now, that's all very well for me to say, but what does that involve in practice? And what should you be planning for? If you're a sole practitioner or a sole principal, I'm afraid you have no choice but to consider your mortality. You should have in place a contingency arrangement for the firm in case you were suddenly no longer able to practice. This could be an arrangement with another local firm, or it could be a list of instructions to family members and fee earners who will be left behind to sort things out. You must back this up with appropriately worded wills and powers of attorney. This will allow others to effect the orderly closure once you're gone. And I'm afraid to labour the point, but I have to. You must prepare both for death and incapacity. If you're in a larger firm, you also need to consider the issue of planning. And in particular, you need to consider what you would do if the managing partner were to suddenly be unable to manage, or that lucrative fee earner were to disappear, possibly to the firm next door. Any size firm can lose a client, although I understand and appreciate that the impact on a smaller firm is far greater than on a large firm. And large firms have lost investors. And then there's retirement. Those of you in large firms can very often retire without too much difficulty because there are colleagues left behind to take your place and carry on for you where you've left off. But this will not be the case for a sole practice. If this is you, you're going to probably want to try and keep the firm going if at all possible. So you need to consider if and how this can be achieved. One way may be to make fee earners you trust directors or partners in the practice so they can continue on after you've gone. If you're a key person in the firm, then there's every chance that the firm will not have a particular value without you. And this being the case, a sale may not be a viable option for you, or you may not be attractive to another firm who will be prepared to be your successor. If this is you, then you need to think in terms of trying to reduce the costs of closure, because professional indemnity can be very expensive, and even closing a firm on a gradual basis is a very expensive option. One way around this may be to start reducing your turnover, or perhaps reduce your high-risk work. That way your professional indemnity runoff will be as cheap as possible, saving for that rainy day. With all other claims and demands on profits, the last thing you probably want to do is save up for the day when you suddenly have to cease practicing or wish to bow out of the profession. It is, however, essential that you make adequate provision for this from the minute you open your doors to the public. Bear in mind that there may be many reasons why you need to make that emergency exit. I have heard from many small firms over the years who have had no option but to continue rather than retire, simply because they cannot afford to close, and frankly, it's heartbreaking. I have identified 6 major expenses for closure. There may be more. The first is runoff cover. This can be 2.5 to 4 times your annual insurance premium. The cost of file storage and the cost of file destruction both need to be done in a secure and confidential way. The cost of storage will be ongoing, and storage companies will expect to be paid. This can be a large cost to you or your estate. On the advice line, we have heard of storage companies threatening to dump files. The cost of someone winding up your practice if you are unable to do so. This involves not only sorting out files, but dealing with accounts issues such as residual balances. Your duty to employees, they may be entitled to redundancy. And lastly, consider when your lease runs out. It's good to talk. When in doubt, and even sometimes when not, liaise with the SRA, particularly in relation to practice closure. You don't need to feel alone in this. Ethics, we are a friendly bunch, and the chances are, at the very least, we can chat things through and direct you to relevant guidance. Whilst we cannot do the thinking for you, we may be able to highlight issues that you have not previously thought of, and sometimes suggest strategies for those that you have. The authorisation team can guide you through the closing process. If you are in financial difficulty, it is particularly important that you contact us at an early stage. This can make all the difference between an intervention which is costly and a managed closure with SRA support behind you. Over the years, we have heard some very sad stories on the advice line. Please do not fall into the trap of thinking that it will not happen to you. Think ahead, save, and be prepared, not only for retirement, but also for the possibility of having to make that emergency exit. Thank you.
Thank you, Jane. So again, if I could ask the floor whether we've got any questions on managing succession. Yeah, I can. There's a gentleman there. It's number 3.
Thank you. My name is Mohammed Ghaffar from Londonium Solicitors. My question is, SR is taking a considerable amount of money in terms of renewing their practicing license, etc. Regarding the succession, is there any plan from SRA to create any benevolent fund or a pension scheme for the solicitors in future? Thank you.
Right, thank you. Are there any plans for? Was it a pension fund for solicitors? Did I hear the question correctly?
So as I understand that, the question was, do we have to plan to set up some kind of scheme? I presume you mean that people can make sort of applications to help support them through these sort of processes. I suppose I can just say not currently. That's not something that I'm aware of as part of our sort of planning going forward. Not something that we've particularly been involved in thinking about or had any kind of queries about beforehand, so I can't pretend that we've thought about it and dismissed it. But it's certainly something that we can take away and give pause for thought. I don't know whether any of my colleagues on the panel know about sort of other access to help and support that people might be able to sort of tap into in these situations, other groups.
It might be worth you having a word with the Solicitors Benevolent Fund. I think they're here today, actually. They do offer financial support in certain circumstances to solicitors who have found themselves in difficult financial situations.
Okay, thank you. That's useful. Have we got any further questions on managing succession? We've got a lady down here with her hand up. Yeah.
Mic 1, please. Hi, I'm Susanna Healy from Radcliffe's. One of the issues that's going to come on succession planning is succession planning for merger. And I have 2 questions arising from the new rules relating to that. So the first is, looking at the new firm authorisation rules, there is no equivalent, unless I'm wrong, of 24.2 in the current rules, which says if you're an unlimited partnership, you are not closing and you don't need new authorisation on the change of a partner. So if I read the new rules right, if you are an unlimited partnership and you appoint a new partner or partner retires, you will need to reapply for authorisation. I hope I'm wrong about that, but I would welcome clarity on the point.
Okay, is that something we have
Rachel may be able to support me with this because she's got far more practical experience, but my understanding is that that's not right and there's no intention to change the position. I think that previous rule was there for the avoidance of doubt because actually that is the situation that arises just by the application of law in terms of we'll look at whether in fact a firm has has ended, the partnership has ended, and whether a new firm has arisen. Am I right, Rachel, in thinking that actually in the situation that you're raising, that's not the case, and we wouldn't be changing the position when the new rules come in from what we do now, which is have that kind of continuity there in terms of the identity of the authorised firm. Yeah.
Thank you. My second question arises from the forthcoming closure of SIF. And I have been unable to trace through the rules what happens when runoff cover expires, in the sense that if I buy a practice and it has got the benefit of runoff cover, at the moment, if runoff cover expires, you can go to SIF on a long tail claim. In future, from 2020, you won't be able to go to SIF, and the original partners of the firm will remain liable. Where I think there is an issue, which also needs clarification, is whether that means the successor practice rules kick back in, so that me as the new firm buying that firm, I become liable for any long tail claims after the end of the runoff period.
Just on that point, firstly, if there has been runoff in place, then what the closing firm will do is confirm that they've elected runoff. So the person that might then pick up the firm afterwards is not a successor practice. That's not how the successor practice rules work. If the firm has bought 6 years' worth of runoff cover, they've elected that, and the insurers know that they need to provide cover for those purposes. So sometimes firms do get confused, thinking that, okay, if we've got a firm that has runoff cover for 6 years, are we still liable? No, because the way the rules are set out, it clearly states that the election process, so the closing firm elects to go into runoff and pays for runoff. It has to be made clear at that point as well that where the firm elects to go into runoff, the insurer will only provide cover in those circumstances where the premium has actually been paid. And that is, again, to avoid circumstances that should there be someone that acquires a part of the practice in future years, that they're not liable for that cover. On the successor practice side of things, again, it's just important to make sure that what we're seeing in certain circumstances is that the acquiring firm doesn't even know that they've become successor practice. And partly it's because, that the definition is quite confusing, but we are seeing some cases, and this is why we have Rachel here today. We've amended our closure form quite significantly to make sure that the person that's been named, or the firm that's been named as successor practice, actually knows that they've been named as successor. We will do our spot checks where we need to. We might call that firm that's been named and said, hi, Jatinder Law has named you a successor practice. Can we just confirm that if that is the case? If that isn't the case, then that opens up a raft of other issues that need to be taken into account in terms of the individual or the firm's integrity. But the process is there to make sure that, if runoff cover has been bought by the closing firm, and I have to stress here that the MTCs do clearly state that where the firm's electing to go into runoff cover, they have to have paid for the premium.
I would say it is something now that we've recognised that we need to check because of obviously instances that we've had, hence why we amended our firm closure process to do those controls.
So hopefully, in terms of runoff, where it's been elected, it has to be paid for. And in terms of successor, there shouldn't be any issues then. Where there isn't any runoff cover, then that's for firms to, I appreciate that with the 6-year expiry and with SIF ending at 2020, what firms have to consider then is their firm as a whole, that, are they confident that their closure or how they manage their business prior isn't likely to give rise to any claims in the future. Thank you.
Well, we've got under 10 minutes left. We're not going to have time to open up a whole new topic, do a presentation and have some Q&As, but actually I'm aware that some of you may have questions beyond the topics we've talked about. So could I ask if anyone's got any questions either on anything we've already talked about or any of the topics that we were going to cover or anything else? More than welcome them. So reporting misconduct, I think, was one of the main ones. Have we got one over here? Yes, sorry. Yes, gentleman over here. If you...
Just carrying on from the previous topic, I'm a sole practitioner. I'm assuming that I have property in all of the papers. If I die in practice, who gets them? Can I leave them to the SRA? would be such a treat for you to find out what practice is actually like instead of just regulating it.
Oh, what's he doing? What, with client papers? Are you talking about client papers?
Yes.
Yeah. Well, you need to make provision for those to be stored until such time as they can be. Yes, you need to make provision for them to be stored until they can be destroyed. If you see what I mean. Now, that if you die, then there needs to be someone else who's going to do that for you, and someone else is going to have to make arrangements for storage and then destruction. And this is why we think it's vital that solicitors plan ahead, and they have powers of attorney in place that will say, right, if I go, then, you know, my friend Bill, who happens to be a solicitor, will wind down my practice for me. And then they will do that. But the costs of storage, I think, will have to come out of your estate.
I'm not talking about historical files. I'm talking about ongoing cases.
Oh, ongoing. Well,
ongoing matters.
Okay. Well, the person who winds up your practice will then be responsible for distributing those files out to other firms. Now, when a solicitor dies, their clients will need to be informed, and they will either have to come and collect their files and go to another solicitor of their choice, or it may be the case that another firm can be recommended to them in accordance with instructions left behind. But ultimately, it is a matter for the client to decide where they want to go.
Thank you. Any further questions? We've got a lady at the end of this row here, a man at the end of that row, and someone in a white jacket, sorry, in the middle. So, yes, a woman in a white jacket.
Hi, I'm Rhiannon from Reliance, and we're a company who firms outsource their risk and compliance to. I've come from a banking background for the last 15 years, so the gentleman who was mentioning about money being sent in error to client accounts, banks do have procedures in place that if money is sent back to them, they will then trace the funds. So I'm just wondering from the SRA's point of view, if law firms were to send the money back as a cheque specifically to the bank rather than to where it's come from, would that be acceptable?
I think, yeah, if you've gone through all those checks and you've documented what you're doing, then that would be a sensible solution in those circumstances, yeah.
Great. So that just gives you sort of further clarification that banks will have a process in place that might be able to help.
That's good, yeah.
Thank you. Yeah, that's great. Thank you. I think we had somebody on an end of a row here, and then a lady in a white jacket in the middle. So yeah, if we go through those two.
David Goodman and Co. In terms of succession planning for small practices and sole practitioners, one of the problems is that we've seen over the last 20 years is that the value of practices for anyone who wants to buy them has gone down massively, sort of with the rise of insurance problems. So would it not be a good idea for the SRA to keep what I would call a private book available to practitioners of small practices and sole practitioners who are thinking of winding down in the next 5 years, which would be available then for practitioners to look at, who then may be able to help with that succession in some way, because at the moment it's a completely closed market and it's virtually impossible to go to a broker and really successfully put a practice on the market, particularly at the small end, because the brokers don't really touch them. There has to be some value attached either in premises or something else usually. But if the SRA were to, bearing in mind this is a regulatory problem which then arises, if the SRA or perhaps the Law Society were to have a a provision whereby someone thinking about retirement or a small practice thinking about possibly closing in the next 5 years, they could register, and then other firms might be able to look at that, and then they could go and talk, express an interest, because at the moment it's completely opaque. No one's got any idea what anyone else is doing.
Okay, thank you. That's a really interesting suggestion. Is there anyone from the panel want to comment on that? It's not something I think we've committed to doing. So.
Other than the fact that someone has mentioned this to me on the phone before.
Oh, okay.
So clearly there are people out there, you know, who are looking out for firms, and also, obviously, speaking to firms every day. There are solicitors, firms who, you know, who want to retire, who are looking out for people who could possibly be a successor to them. So
I think it's an incredibly interesting and helpful and practical suggestion, and it's certainly something that we can look at how we might take that forward. And I think, as you say, very sensibly discuss it with the Law Society and think about how we might work together with them to try and help, because clearly there is a need for that sort of network to be sort of brought together. And as you say, useful from a regulatory point of view for the information to be with us about who is planning, who, you know, what people's plans are, but also to make sure that people have the support that they can get to ease that process. So that was really very useful.
I think we did have, the SPG, Sole Practitioners Group, did have some sort of initiative that was similar to this before, where they were using their web portal and their solo magazine for people to advertise or just make an announcement that they were looking to close their practice. So whether it's something that we work with the SPG on. The SPG are here today as well, so it might be something that you know, they might want to pick up again after discussions with people here.
Thank you. Well, I certainly don't want to keep all you guys from lunch, so we are nearing the end of this session, but I promised there was a woman in a white jacket, I think in the middle, who had a question, so if by number 3, yes, so if you'd like to go ahead and ask a question.
Yes, hi. Maria Puglisi, National Legal Service. My question is about ABS firms and how would the changes impact the ABS firms in a nutshell? Is there anything that's going to change significantly? Do we have to prepare for anything in the specifics? There will be guidances published around? Just asking in general, what is the position?
At a very high level, know how you operate. I suppose it's more about how, with ease of moving forward, our rules will be, so that it will be easier in excess, that you'll have a firm section and individual sections. You'll be able to navigate if you've got queries in the future. Equally, though, you can come to authorisation or you can go to ethics on that at a high level. That's there's no significant things for you to be with, but we will be publishing guidance and targeting our communications for different types of bodies to help you moving forward. Juliet?
Well, I think we're now just past 1/4 which is for the end of this session. So thank you ever so much for coming along and having so many questions for a session that had the advice to consider your own mortality. I thought it was a very good session. Could I ask just one final thing for you? On the app, if you're on there, you can rate this session. This session is a bit different to ones we've done previously, so we'd really like to know whether it's useful. But I will stop talking now. The breakout sessions start again at 1:50, so go off and enjoy your lunch. Thank you.